Senator Kyle.
Thank you, Mr. Chairman. First of all, Senator Grassley asked me just one thing here. Attorney General Holder, is my understanding correct that you will not commit to providing Senator Grassley a list of your recusals?
A list of my recusals?
Yes. The list of recusals that he was requesting when he examined you just a moment ago.
What I said was that I would consider that request.
Yeah, so my understanding is correct that you're not committing to provide that for him. Is that correct?
I said I would consider it.
You have repeatedly said that your decision to try Khalid Sheikh Mohammed in Article 3 courts is because that's where you have the best chance to prosecute, that the chances of success are enhanced in Article 3 courts, and that you have access to all the evidence, so you're in a better position to judge than those who are ignorant of that evidence are. How could you be more likely to get a conviction in federal court when Khalid Sheikh Mohammed is already asked to plead guilty before a military commission and be executed? How could you be more likely to get a conviction in an Article 3 court than that?
Well, Senator, you're dealing with...
In these hearings, as I always do, whether people are supportive or opposed to any position I take, that we must have order. We will have order. The police will remove those who don't.
Mr. Chairman, let me say that your request for order is exactly appropriate, and I concur with that. Could you answer my question, Mr. Attorney General?
The determination I make on where I think we can best try these cases is not dependent on the whims or the desires of Khalid Sheikh Mohammed. He said he wanted to do that then. I have no idea what he wants to do now with regard to these military commissions that, as a result of the work that this committee did and this Congress did, now has enhanced protections and I think are better than they once were before. He may still want to do that in a military commission. I have no idea. My job is to look at the possibilities. Article 3, military commission, where is my best chance of success?
Well, if I could interrupt, it would seem to me that given the fact...
I decided that Article 3 courts were the best place to do that.
Right. I know that's what
Sheikh Mohammed is not making this decision. The Attorney General...
Of course he's not. Mr. Attorney General, you've based this on where you think you're more likely to get a conviction. You talked about the best chance to prosecute, the chances of success are enhanced, and so on. One of the factors has to be the fact that he has at least at some time asked to plead guilty. I mean, you had to have taken that into account.
That was then. I don't know what Khalid Sheikh Mohammed wants to do now, and I'm not going to base a determination on where these cases ought to be brought on what a terrorist, what a murderer wants to do. He will not select the prosecution venue. I will select it, and I have.
But my understanding is that one of the key reasons for your decision is where you think you're going to have the best chance of success. One would think that his expressed desire to plead guilty in the military commission would have some effect on your decision.
Well, Senator Kyle, with all respect, today is, I don't know, November 16th, 17th, I'm not sure what the date is. Do we know as a fact right now that that is in fact what he wants to do? Do we know that? Do I have some special information? Do you have some special information that is what Khalid Sheikh Mohammed is planning to do or continuing to plan to do?
Why is it more likely that he will be convicted in a federal court than he would before a military commission, particularly given the fact, surely you're not arguing that it's easier to get evidence in to an Article 3 court than it is in a military commission. I mean, you made the point that you're aware of a lot of evidence in this case that others aren't, of course, but the rules for admitting evidence are more lenient before military commissions than in Article 3 courts. So that can't be the basis for your decision, is it?
That is not necessarily the case. With regard to the evidence that would be elicited in a military commission, evidence elicited from them, from the detainees, from the terrorists as a result of these enhanced interrogation techniques, it is not clear to me at all that that information would necessarily be admitted in a military commission, even with the use of a clean team, or that it would withstand appellate scrutiny. And on the basis of that concern and other things, my desire to go to an Article 3 court and to minimize the use of that kind of information, that kind of evidence, I thought was paramount.
Suppose that another terrorist of the same kind as KSM argues that he too should be tried in an Article 3 court, but he's one of the ones destined for a military commission. On what basis do you argue against that that request, since this appears to be simply a subjective judgment on your part as to which court it's easier to get a conviction in?
It's not a question of where I think we can get an easier conviction. It's a question of looking at the protocol that exists, talking to the Secretary of Defense and other people and trying to make determinations of where cases are more appropriately held. The case, for instance, involving the Cole that involves Mr. Nashiri, an attack on an American warship, it seems to me, is something that is uniquely situated for a military commission as opposed to an Article 3.
But how do you answer the rationale that the more heinous crime is the killing of civilians, and therefore is more ripe for resolution in military commission than in Article 3 court?
I'm not making value judgments about which case is more heinous or which lives are more valuable. I'm looking simply at the facts and at the protocols and trying to make determinations as to where cases are appropriately cited.
It's hard to understand a rationale, though, that when you kill 3,000 almost civilians, that therefore calls for Article 3 as opposed to military commission. The logic of that escapes me.
Well, the federal law that governs the administration of the death penalty dictates that cases should be brought in the place where the offense occurred. So that is at least another factor that I think has to be used in trying to determine where the cases should be brought.
Well, that assumes that the person is in the United States for one thing and he is not. Let me just close with this point. You said, and this really bothers me, Mr. Attorney General, with all due respect, for 8 years justice has been delayed for the victims of the 9/11 attacks. I want to put in the record, Mr. Chairman, ask unanimous consent to insert in the record an article called Justice Delayed by Andrew McCarthy.
Objection.
I'll just quote two paragraphs from this. This is chutzpah writ large, he writes. The principal reason there were so few military trials is the tireless campaign conducted by leftist lawyers to derail military tribunals by challenging them in the courts. Many of those lawyers are now working for the Obama Justice Department. That includes Holder, whose firm, Covington & Burling, volunteered its services to at least 18 of America's enemies in lawsuits they brought against the American people. And he concludes, within 2 years, KSM and 4 fellow war criminals stood ready to plead guilty and proceed to execution. But then the Obama administration blew into Washington. Want to talk about delay? Obama shut down the commission, despite the jihadists' efforts to conclude it by pleading guilty. Obama's team permitted no movement of the case for 11 months. And now has torpedoed a perfectly valid commission case, despite keeping the commission system for other cases, so that we can instead endure an incredibly expensive and burdensome civil trial that will take years to complete. The witness can surely respond to what I said.
I don't even know where to begin. Other than to say that, this notion of leftist lawyers somehow prolonging this, the vast majority of the time in which these matters were not brought to trial, to fruition, happened in the prior administration. The Supreme Court, not, I think, a group of leftist lawyers, had concerns about the way in which some of the commissions were, the way in which the commissions were constructed. The Congress reenacted, and I think appropriately so, the way in which the commissions were constructed. This is not a Congress peopled only with leftist lawyers, as Mr. McCarthy would say. So, that makes for nice rhetoric, and it makes for, good, I guess, fodder on the talk shows and all of that stuff. But I'm here to talk about facts and evidence, real American values, and not the kinds of polemics that he seems prone to. So, that's I'm not worried about Mr. McCarthy.